Think about this for a second. Right now in the United States, women hold trillions of dollars in personal wealth. They open accounts, sign mortgages, take out business loans, and move money across the world from a phone in their pocket without asking anyone's permission. It is so ordinary that it feels like weather, like it was always there. Now go back 65 years. In 1960, a woman could walk into a bank with a steady job, a paycheck in her hand, and not a single missed payment in her life, and be told to come back with her father, or her husband, someone who could sign for her. Most people assume there must have been some law that made that happen, some ugly statute on a dusty shelf that Congress eventually repealed, and everybody moved on. But here's the thing. There was no law. Not a federal one. Not a single line in the United States Code that said a woman could not walk into a bank and open an account in her own name. And that is not the good news. That is what makes it so much worse. Because a bank could look at a woman with a job, a paycheck, and a spotless record and tell her to come back with her husband. And it was breaking absolutely nothing. There was no rule to break. There was only a practice, and the practice was older than the country. So if it wasn't the law, what was it? What exactly was a bank manager enforcing when he slid the paperwork back across the counter and asked for a man's signature? And why did it take until 1974, the year of Watergate, the year Hank Aaron broke the home run record, a full 5 years after human beings walked on the moon, for the federal government to finally write the words down? The answer runs through a 700-year-old legal doctrine that Americans imported and never really examined. It runs through a woman who passed the bar exam and was told she couldn't practice law because she had a husband. It runs through a mother in Idaho who lost her son and then lost the paperwork fight over his $400. And it ends in a committee room in Washington at the end of a long night with a congresswoman who took the draft of a bill, wrote a few words into it by hand, and photocopied it for every man in the room before any of them could object. She didn't win that argument. She made sure there wasn't one. But we're getting ahead of ourselves. Because to understand what she was fixing, you have to understand the thing that had been sitting underneath American law, quietly, since before there was an America. In 1765, an English legal scholar named William Blackstone published the first volume of his Commentaries on the Laws of England. It was the most influential legal textbook in the English-speaking world. Every lawyer in the American colonies learned from it. Every judge cited it. When the framers wrote about law, Blackstone was the water they swam in. And in that book, Blackstone described a doctrine called coverture. He put it like this: by marriage, the husband and wife are one person in law. The very being, the legal existence of the woman, is suspended during the marriage, or at least it is incorporated and consolidated into that of the husband. Read that again. Not reduced, not limited, suspended. The French legal term for it was femme couverte, the covered woman. The husband was the cover. He was the legal surface she existed underneath. And in practical terms, here is what that meant for a married woman in colonial America and in the young United States. She could not sign a contract. Not a lease, not a bill of sale, not a promissory note. Her signature had no legal weight, because legally, there was no separate person there to sign. She could not sue, and she could not be sued in her own name. If someone wronged her, her husband brought the action. If she wronged someone, he answered for it. She could not write a will disposing of property without his consent. Property she owned before the marriage, land, money, furniture, livestock, came under his management the moment the vows ended. Personal property often became his outright, and her wages. If she worked, and enormous numbers of women worked as laundresses, seamstresses, domestic servants, mill hands, boarding house keepers, the money she earned was legally his, not shared, not jointly held, his. An employer could pay her wages directly to her husband, and that was not theft. That was the correct handling of his property. Now here's the part that surprises almost everyone, and it's the detail that makes this whole story stranger than it first appears. An unmarried woman didn't live under this. She was femme sole, a woman alone, and she could own property, sign contracts, run a business, sue in court, and keep her own earnings. A widow got those rights back the day her husband died. In colonial port cities, you can find women running taverns, importing goods, holding real estate, and suing debtors, all perfectly legally because they were single or widowed, which produces one of the strangest facts in American legal history. Coverture wasn't triggered by being a woman. It was triggered by the wedding. The ceremony that a young woman was told would be the happiest day of her life was, in the most literal legal sense, the single day on which she would lose more rights than on any other day she would ever live. Imagine that for a second. You're 22 years old, working 6 days a week in a Lowell textile mill in 1845. The noise is constant. The lint hangs in the air. You are exhausted in a way that doesn't go away on Sunday. But the money is yours. You keep a little tin box under the bed, and it has $4 in it, and every one of those dollars you put there yourself. Then you get married, and the tin box is his, not because he took it, because the law says there is no longer a you for it to belong to. Next Friday, your foreman can hand your pay envelope directly to your husband and never see you at all. If he spends it at a tavern, there is no crime, no claim, no court that will hear you. It was never yours to lose. That was not an abuse of the system. That was the system, working exactly as designed. And here's what I find most telling about it. Coverture was not sold as a punishment. It was sold as protection. The reasoning went like this. Commerce is harsh, contracts are dangerous, litigation is brutal, and a woman should be shielded from all of it. Her husband absorbed the risk so she wouldn't have to. Under coverture, he was also legally obligated to support her, to house her, to pay her debts. It was framed as a trade. Shelter for autonomy. It's the same rhetorical move you find under almost every restrictive system in history. The cage explains itself as a roof, and for 200 years almost nobody in American public life could articulate a reason it should change. Then a legislature in Mississippi changed it, and they did it for one of the ugliest reasons imaginable. In 1839, Mississippi passed the first Married Women's Property Act in the United States. It let a married woman hold property in her own name, separate from her husband. It sounds like a landmark for women's rights. It was, in effect. But that is almost certainly not why it passed. The law grew out of a case involving a Chickasaw woman named Betsy Love Allen, whose property under tribal custom had never merged with her husband's, and the property in question included enslaved people. And the broader appetite in the legislature was not about female autonomy at all. It was about creditors. Planters in the 1830s were drowning in debt after a financial panic. If a wife's property was legally her own, her husband's creditors couldn't seize it. Putting assets in a wife's name was a shield. So the first crack in coverture in American history was opened, in large part, by men trying to protect wealth, including human beings held as property, from collection agents. I'm telling you that because this story is full of moments where the right thing happens for the wrong reason, and if I skipped them, you'd be watching a fairy tale instead of a history. New York moved next and moved further. The Married Women's Property Act of 1848 passed the same year as the Seneca Falls Convention in the same state, in an atmosphere that was very much charged. Let married women hold real and personal property free of their husband's control and debts. Then in 1860, New York went to the heart of it, the Earnings Act, which finally said that what a married woman earned by her own labor was her own separate property, her wages, hers, in 1860. Roughly 84 years after the Declaration of Independence announced that certain truths were self-evident. Other states followed through the 1850s, 60s, 70s, 80s. By the end of the century, most of the country had some version of these statutes on the books, and the formal doctrine of coverture was in retreat almost everywhere. But here's the critical detail that most people overlook, and it is the thing this entire video is actually about. Passing a law and changing a bank counter are two completely different events. Every one of those statutes told the government what it had to recognize. A court had to accept her deed. A registry had to record her title. A judge had to hear her lawsuit. That is enormous, and it mattered. But none of them told a private business what to do. Nothing in those acts said a bank had to open an account. Nothing said a department store had to extend credit. Nothing said a lender had to accept a woman's signature on a mortgage without a man co-signing beneath it. Private institutions kept full discretion over who they would transact with, and they used it. So a gap opened. On one side, a woman with the legal capacity to own anything she could pay for. On the other, a private financial system under no obligation whatsoever to deal with her. That gap stayed open for another 114 years, and in 1873, the Supreme Court looked directly at that gap and decided it was fine. Myra Bradwell was, by any standard, more qualified for the practice of law than most men admitted to it. She had studied law, she ran a legal newspaper in Chicago that lawyers and judges across the region actually relied on, and she passed the Illinois bar examination. Illinois refused her a license. The stated reason was her status as a married woman. Under coverture, she couldn't enter into contracts, and a lawyer's work is contracts. She took it to the Supreme Court of the United States, and she lost. The opinion itself turned on a narrow reading of the 14th Amendment. But it's the concurrence that history remembers, written by Justice Joseph Bradley. And it's worth sitting with because it tells you what the objection really was. Bradley wrote about the natural timidity and delicacy of the female sex, and about how the paramount destiny and mission of woman were to fulfill the offices of wife and mother. He called it the law of the Creator, not the law of Illinois, not the law of the United States, the law of the Creator. That's the year 1873. The country had just decided, in state after state, that a married woman could own a house. It had not decided she was a person who could sign for one. Then the world went to war, twice, and something strange happened. During the First World War, and far more dramatically during the Second, American women entered the paid workforce in numbers nobody had planned for. Defense plants, shipyards, aircraft factories, offices, transit systems. 6 million women joined the workforce during World War II. They earned real wages, and they earned them in their own names, and the banks noticed. War bond drives were aimed squarely at women. Banks ran advertisements courting the working woman's deposits. Institutions that had never much cared to serve a woman alone discovered a sudden enthusiasm for her savings account because the deposits were real and the deposits were needed. For a few years, in a lot of places, a woman could walk in and open an account on her own signature and nobody blinked. Here's the trap, and it's the same trap that runs through the whole century. None of it was written down. It was not a policy change. It was not a right. It was commercial expedience during a national emergency. Nothing had been amended. Nothing had been enacted. Nothing had been promised. The bank was being flexible because flexibility was profitable, and when the emergency ended, so did the flexibility. After 1945, the men came home and women were pushed out of industrial work in enormous numbers, sometimes by explicit policy, sometimes by layoff order, often by simple social pressure. The American financial system reorganized itself around a specific imagined customer, the suburban household with one earner, one mortgage, one car loan, and one signature that mattered. And that reorganization left an artifact. A small one, physical, that sat in millions of purses for decades. Go find a photograph of a woman's checkbook or store charge plate from the 1950s or 60s, and look at the name embossed on it. It doesn't say her name. It says Mrs. John Smith, not Mary Smith, not Margaret. Her husband's full name with a courtesy title bolted onto the front of it. That was the standard convention, printed by the bank on the instrument she used to spend money, a lot of which she had earned. Her own financial identity in her own hand, addressed to a man. Hold on to that, we're coming back to it. Because by the 1950s and 60s, the practices had hardened into something close to a national system, and it looked like this. A married woman applying for a loan would routinely find her income discounted, counted at half or a third, or not at all, on the theory that she would soon have children and stop working. Lenders asked openly on the record in application interviews whether a woman used birth control and whether she intended to become pregnant. Some required a letter from a doctor. Some required a signed statement from the husband. A single woman could be refused a mortgage on a house she could easily afford because a woman alone was considered an unstable borrower. A divorced woman with 15 years of perfect payment history could discover she had no credit history at all because every account, every card, every loan had been reported under her husband's name. The record existed. It just wasn't hers. She had spent 15 years building a file for someone else. And a widow, in the worst version of it, could bury her husband on Tuesday and be told on Wednesday that her cards were canceled and she'd need to reapply, as a new customer, with no history, at 48 years old. None of this was illegal. That's the part people struggle with. There was no statute being violated. There was no agency to complain to. There was no court that would hear it, because a private business had a general right to choose its customers, and it was choosing. And if you think this was purely informal custom, consider Louisiana. Louisiana had what were called head and master laws. Under them, a husband had unilateral control over jointly owned community property. He could mortgage the family home, property she legally co-owned on without her knowledge and without her consent. Not in 1890. Louisiana's head and master statute survived into 1979, and the Supreme Court didn't strike down the challenged version until 1981. 1981. That is after the Rubik's Cube, after Pac-Man, after MTV launched. But before any of that, the thing that finally cracked the wall open didn't start with a bank or a mortgage or a credit card. It started with a mother in Boise, Idaho, whose son had died. Sally Reed was a homemaker in Boise who took in disabled children for care. She and her husband Cecil had separated years earlier. In 1967, their teenage son Richard died. He left behind a small estate, some savings, some personal effects. The total value was under $1,000, by most accounts a few hundred. A clarinet, a bank account, some belongings. The kind of estate that gets settled in an afternoon. Sally Reed petitioned to be named administrator. Her estranged husband filed a competing petition. And the Idaho probate court didn't weigh their qualifications. It didn't hold a hearing on who was better suited. It couldn't. Because the Idaho Code contained a mandatory rule for exactly this situation, and the rule said that as between persons equally entitled to administer an estate, males must be preferred to females. Not may be preferred. Not shall be considered. Must. The state's defense of the rule, when pressed, was essentially administrative convenience. Probate courts are busy. Hearings cost time. A flat tiebreaker is efficient. Pick the man, move on. So Sally Reed lost her son, and then a court told her that on the question of her own child's belongings, the law required it to prefer a man it had not evaluated to a woman it had not evaluated because of what they were. She appealed, and she kept appealing for 4 years over an estate worth less than the cost of the appeals. Her case was taken up by the American Civil Liberties Union, and the brief filed with the Supreme Court was written by a young law professor named Ruth Bader Ginsburg, along with Melvin Wolfe. Ginsburg's argument was, at the time considered a long shot, that the Equal Protection Clause of the 14th Amendment, the clause written in the aftermath of the Civil War, applied to discrimination on the basis of sex. The court had never struck down a law on those grounds, not once in the entire history of the 14th Amendment. In November 1971 it did, Reed versus Reed. The decision was unanimous. Chief Justice Burger wrote it, and the reasoning was almost anticlimactically plain. A state cannot choose between two people on the basis of sex simply because it's convenient. That is arbitrary. That is forbidden. It's one of the most consequential paragraphs in 20th century American law, and it exists because a grieving mother in Idaho refused to let $400 go. But, and here is the pattern repeating one more time, Reed did not fix the bank. Reed bound governments, states, agencies, courts, statutes. It told every legislature in America that it could not write sex into its laws as a sorting mechanism. It said nothing at all about a branch manager in Cleveland who preferred a male signature. The Constitution restrains the state, it does not restrain a loan officer. So the wall came down on one side and stayed up on the other. And by the early 1970s, Congress was finally hearing what that felt like. The National Commission on Consumer Finance held hearings. Congressional committees took testimony. And the record that came out of those rooms is remarkable, because for the first time the practices got said out loud, on the record, by the people they happened to. Women with high incomes and long employment histories denied cards routinely issued to men earning far less. Married women told their salaries would be counted at 50% or zero in a joint mortgage application. Divorced women discovering their entire financial history belonged to an ex-husband. Single women asked, by a stranger at a desk, about their reproductive plans as a condition of borrowing money. And underneath all of it, one sentence said in 100 different ways by 100 different institutions, "Come back with a man." By 1974, Congress was moving on a bill to address discrimination in lending. It would become the Equal Credit Opportunity Act. The bill had momentum. It had support in both chambers. And as these things do, it went into conference committee, where House and Senate versions get reconciled into a single text and where enormous amounts of substance quietly disappear into the seams between drafts. Now picture the room. Late in the process. Long day. A stack of paper on the table that nobody in it has read cover to cover in its final form. The kind of room where important things get decided by the people still awake. Representative Lindy Boggs of Louisiana was in that room. She was the only woman on the House Banking Committee. She had come to Congress 2 years earlier by winning the seat of her husband Hale Boggs, the House Majority Leader, after his plane disappeared over Alaska. Boggs read the draft language on prohibited discrimination. It covered race. It covered color. It covered religion, national origin, age. It did not say sex. It did not say marital status. The entire category of exclusion that had defined American women's relationship with credit for a century and a half, the thing the hearings had documented in exhausting detail, was simply not in the text. Whether by oversight, by drafting compromise, or by design, it wasn't there. So Boggs took the draft and she wrote the words in by hand. Sex or marital status, inserted into the list in pen. Then she went and had the amended page photocopied for every single member of the committee, walked back in, handed the copies around and said, with the warmth of a woman who had spent decades in Washington rooms and understood precisely what she was doing, that she knew they had all intended to include women and heads of household, that it had obviously been an oversight, and that she'd taken the liberty of correcting it for them. Nobody objected. Of course nobody objected. What was the man going to say with the copies already in every hand and his name on the committee, that he'd meant to leave it out? She didn't win the argument. She made sure there wasn't one. The Equal Credit Opportunity Act was signed into law in October 1974 and took effect the following year. For the first time in American history, it was federally illegal for a creditor to discriminate against an applicant on the basis of sex or marital status. A woman could not be required to produce a husband's signature on a loan she qualified for. Her income had to be counted. Her application had to be judged on the same terms as a man's. And she had the right to have credit reported in her own name, to build a file that was hers, Stop and sit with the mechanism of it for a second. Coverture came to America inside a textbook. It lasted the better part of 2 centuries. It was chipped at by state legislatures for creditor protection reasons, narrowed by a grieving mother in Idaho over a few $100s, and finally, formally ended in the private economy by a few words that a congresswoman wrote into a draft in pen and photocopied before anyone could argue. Not a movement's triumphant floor vote, not a constitutional amendment. Paperwork. What happened next came fast. Enforcement gave the law teeth. Credit bureaus began building files in women's own names. In 1975, the first women's bank opened in New York City, founded by women, run by women, created specifically because the existing system had spent a century treating women as dependents. And there was still work left, which tells you how deep this went. Because in some states, well into the 1980s, a woman starting a business could still be required to bring a male relative to co-sign a commercial loan. Consumer credit had been covered in 1974. Business credit hadn't. That didn't get closed until the Women's Business Ownership Act of 1988. There are people watching this video who were already in the workforce. This was never really a story about bank accounts. It's a story about who counts as a person who can sign. And America answered that question 3 separate times in 3 different places and never once at the same time. Think of it as 3 locks on the same door. The first lock is legal identity. Can she hold property, sign a contract, and stand in court as herself? That lock was picked slowly, state by state, from Mississippi in 1839 through the Married Women's Property Acts of the 1800s. Call it open by roughly 1900. The second lock is income. Is the money she earns treated as hers, and can she earn it on equal terms? New York's Earnings Act said yes in 1860 as a matter of statute, but the practical version needed the Equal Pay Act of 1963 and Title VII of the Civil Rights Act in 1964 to mean much. Call it open in the mid-1960s. The third lock is credit. Will a private institution transact with her, alone, on her signature, without a man attached? That lock did not open until 1974. For business lending, 1988. 135 years between the first lock and the third. And here's why that matters more than any individual date. She needed all 3. Holding 1 or 2 was, functionally, holding none. Owning property you can't borrow against is a museum piece. Earning a salary that a lender refuses to count is a number on a pay stub. Legal capacity without financial access is a right you can describe but not use. The locks only mean something together, and for a century and a third, they were never all open at the same time. Now, I want to be careful here, because the honest version of this history is more complicated than the angry version. Plenty of women banked, borrowed, and built through every decade of this story. Widows ran businesses in the 18th century. Single women held property and mortgages in the 19th. Some states were far more liberal than others. Some bank managers simply ignored the conventions and opened the account because the woman in front of them was obviously good for it. Immigrant communities and black communities built their own mutual aid societies and lending circles precisely because mainstream institutions wouldn't serve them, and enormous amounts of real economic life happened inside those networks. Many families paid no attention to any of it and ran their money however they pleased. All of that is true. None of it was a right. It was permission. Permission from a state, a statute, a manager, a husband, a moment of wartime convenience. And the defining property of permission is that it can be withdrawn without notice by someone who never has to explain. That's the difference 1974 made. Not that women started handling money. Women had always handled money. It's that for the first time, the answer stopped depending on who was behind the desk. Go back to that checkbook, Mrs. John Smith. That convention has gone. You won't find a bank printing it today. But look at what replaced it, and ask what actually changed. The widow after a 40-year marriage who discovers her credit file is thin because the accounts were opened in his name and reported under his history, and she is 69 years old applying as a stranger. The mortgage documents where he is listed first because he was listed first on the application because he made the call. The persistent gaps in business lending, in approval rates, in loan size, in the rate at which women are asked for collateral or a cosigner that a comparable man is not asked for. The name on the card changed in 1974. It's worth asking carefully and without hysteria how much of the architecture underneath it changed with it. And go back to Blackstone too. That sentence from 1765. The husband and wife are one person in law, and that person is the husband. For most of American history, that wasn't a metaphor. It was the operating instruction. Every restriction we've walked through, the wages, the contracts, the signature, the head and master laws, the man's name on the checkbook, is a downstream consequence of that one sentence being taken literally, and the last American law built directly on it was struck down in 1981. Which brings me to the fact I can't stop turning over. The Equal Credit Opportunity Act is more recent than the moon landing. We landed human beings on another world, and then waited 5 more years to make it federally illegal to tell a woman with a paycheck to bring her husband. The women this happened to are not historical figures. They are in their 70s and 80s and 90s. They are at Thanksgiving. Some of them are still married to the man whose signature they once needed, holding a joint account they were once not permitted to open alone. If you have a grandmother and you ask her what happened when she tried to get a card or a car loan or a mortgage in 1968, you will not get a history lesson. You'll get a memory, and it'll be sharper than you expect. Because that is the strange, uncomfortable shape of this whole story. It was written by inheritance, a doctrine we imported from another country and never argued about. It was preserved as protection, sold to the people it constrained as a kindness. It was cracked by creditors trying to hide assets, and by a grieving mother over $400. And it was finished by a sentence somebody wrote in by hand, late at night, and photocopied before the room could think about it. Not one line of that was inevitable. Any of it could have gone the other way, and for a long time it did. That's the real story of how a woman got the right to sign her own name. If this changed the way you think about what a right actually is, the difference between something you're permitted to do and something no one can take from you, hit subscribe. We go deep on these stories, the ones about how power and money really work, and the next one is about a legal strategy almost nobody talks about, how Ruth Bader Ginsburg spent a decade deliberately bringing cases on behalf of men, and why that was the only way to win. There's a lot more coming.